Baca, thank you for joining us, and for the audience on webcast, would you please introduce yourself?
Hello. Can you hear me?
Don't start quite yet. We're doing one more legislative introduction. Okay.
My apologies. Thank you.
That's all right, and then you'll be on. Senator Baca, are you with us? Okay, well, if Senator Baca comes on and starts speaking, just know that he joined us recently and he's up for an introduction. So we will go ahead, Ms. LaCruz Crawford, and you're presenting today on natural resource protection and prosecution of violations. Welcome to the Land Grant Committee, and thank you for being here.
Thank you, Madam Chair. So I don't know if Sarah's on and if she could pull up the PowerPoint presentation. Yeah, not that document, the actual PowerPoint presentation.
I actually don't believe I had a view with the title, the other document I have.
I'm sorry, I'm having difficulty hearing you, but I sent the materials yesterday, and I sent them to Mark.
Okay.
It was in that same email with that document that you pulled up just a second ago.
Okay, is it this is the other one I have.
Right, that would be the third. So those are the handouts.
Okay, 1 second then. If you want to get, well, you probably need yours. If you have it,
I'll start with the first page while you try to find that. I'll give an introduction. Okay, so
emailed it to me, so.
Okay, and make sure you pull up. I also, just so you know, Sarah, I also emailed you a PDF of the PowerPoint to give to the council members. Don't pull up the PDF. Pull up the actual PowerPoint, so you can go from slide to slide. Okay.
Email me the PowerPoint now.
Okay, great. All right. So my name is Andrea LaCruz Crawford, and I am a Santa Fe attorney. And I've been working over the past 2 years on issues of natural resource protection on land grants, and specifically on how to enforce bylaws that are adopted to protect natural resources in a way so that they can be used by future generations. Those bylaws usually involve some sort of payment of a fee application for a permit that has limitations on the type and quantity of resource the air may remove, and how they're removed, and the location they're removed from. So today I am presenting on challenges in natural resource protection, prosecution and enforcement, and the need for creative legislative solutions to address really a multitude of problems with the system and the way that it currently is set up. 2 things that I want to point out before I actually begin my presentation is just that I'm not going to be discussing any specific actions which I'm currently involved in litigation on. I may kind of generally mention issues that I have experienced, but all of these presentations are my own opinions. They don't necessarily reflect the opinion of my clients, and this is all just stuff that I've kind of garnered from my own personal experiences, and I'm hoping that we can put forward some proposed solutions, but I want to be clear that those are just ideas. They are brainstorming. They're not polished products being presented for consideration. They're just food for thought. So I just want to put that out there and put that on the table before we get to it, because I did draft some proposed legislation just to give kind of an example of something that could be done. But that doesn't mean that any of it's a good idea. So we need to have the discussion, but those are some thoughts I had. So we'll get into that at the end of the presentation. Okay, so if we could move on to the first slide. So the first thing I want to talk about is, and most of you probably all already know this, but a land grant Merced has certain statutorily defined powers that are granted to a board of trustees that manages the land grant Merced. Now, a land grant Merced is different than a private land grant. I mention this because a lot of people are not aware of that. I know most of the council will be aware of that. But basically, a land grant Merced is a grant of land made by the government of Spain or the government of Mexico to a community, town, colony, or pueblo, or to a person for the purpose of founding or establishing a community, town, colony, or pueblo. And they have a very unique position within the law because they are political subdivisions of the state of New Mexico. They're managed according to their own bylaws, and the Treaty of Guadalupe Hidalgo and the New Mexico statutory provisions, which are outlined in 49.1.1 through 49.1.18 of the New Mexico state statutes. Okay, next slide, please. Under the statute, specifically 49.1.3, the board has specific powers, and this is really just a portion of the powers they have, but these ones are the ones related to natural resource protection. They can manage land grant, Merced, and real estate, prescribe the terms and conditions under which common lands can be used and enjoyed, and make all necessary and proper bylaws, rules, and regulations. They can sue and be sued. That's an important thing to note. It also allows them to prescribe prices to be paid for the use of common lands and resources, and to prohibit a person from failing or refusing to pay that amount from using a portion of the common land. They can make bylaws, rules, regulations not in conflict with the Constitution and the laws of the United States or the state of New Mexico, to protect, improve, manage, and take care of the real estate for the common use of the land and water of the land grant. I also wanted to mention that they have powers as well for land use, infrastructure, economic development. So those are the powers of the land grant under 49.1.3, the Board of Trustees of the land grant, I should say. Now this slide, actually, I'm going to just skip. I just wanted to put it, I put it in there initially thinking that I was going to talk about it, but it's really not going to apply to anything I'm doing. So go ahead and skip to the next. Okay, so I want to go straight into talking about enforcement issues. All right, next slide. So the first major issue is just that the land grants are enormous as compared to the size of the Board of Trustees, who are delegated power to manage those land grants. For instance, I represent, one of the clients I represent is the Anton Chico Land Grant, which is the largest land grant in the state of New Mexico. It's roughly, there's some dispute about the amount of land in the land grant, but it's roughly 114,000 acres, which, if you, just for comparison, is about a quarter the size of Rhode Island. So it's an enormous expanse of land, and it spans portions of 2 counties, both Guadalupe and San Miguel, and all of that is managed by a 5-member Board of Trustees. I also want to mention that a Board of Trustees receives nominal compensation for their services. They are exposed to potential litigation. A lot of time can be involved in terms of trying to enforce the rules and the regulations of the land grant. I think that that's something else that maybe should be looked at. I also want to clarify that I did kind of misspeak in my text here. I put that there's no designated enforcement arm, branch, or authority. There is enforcement authority, but it's civil enforcement authority. So I want to be clear that there's no criminal enforcement authority. So if a member of the Board of Trustees goes out to enforce a violation, they just go out and they witness it and they can tell them to stop doing it. But if they don't stop, they really can only, their option then is to try to call the police department. And as we'll discuss, that doesn't usually ever turn into something productive as far as that's concerned. So for instance, what I've advised my clients to do is if they see a violation, they just have to document it. And then we have to file a civil suit in the courts to try to actually stop the violations from continuing to occur. So I just wanted to mention that currently the land grant board can create enforcement officials, for instance, under their existing bylaws, but they only have the same, they can only utilize the same powers that they have under the statutory provision. So it's purely civil authority. They don't have any criminal authority. They can't issue, and this is something we'll talk about later, like a citation or do anything to force somebody to kind of comply with that more quickly than filing a civil lawsuit. Okay, next slide. So this just shows what the statutory provisions provide that the Board of Trustees can be paid as far as a salary, which is for, here's $200 per month for a member of the board, which includes, basically all of their attendance at regularly scheduled meetings and everything they do in between. They are also allowed per diem under the Mileage Act, but it's still very nominal compensation. Okay, so next slide. The second major issue that I wanted to discuss are violations, and I've already referred to it a few times, is that just that violations are civil and not criminal. So one of the problems we run into is that the Board of Trustees will go out to try to enforce a violation and can't get law enforcement to come out and support their efforts. So, I have seen situations where there has been someone who's going out to the land grant basically daily, and we can't get the police department to go out one time to write up a police report that we can use to start our civil complaint. Now that said, we can use the testimony of the officers, but there's a lot of things that have to be documented, which we'll go through as well to just show the practical challenges that the board faces when they actually are trying to deal with this. I also want to express my concern that a lot of the time, due in part to understaffing of the police departments, if a land grant lies within multiple jurisdictions, we kind of see the jurisdictions, saying, oh no, we're not responsible for enforcing this. You should call the other, if like the San Miguel County might say, you should call Guadalupe County. We think it's in Guadalupe, and they'll say you should call San Miguel, and then they'll both say you should call state police. And then by the time you've called state police, the person who you're trying to enforce the violation against may already be gone. So it causes a lot of issues. Also, the police departments are hesitant or unwilling to enforce bylaws without, actually having received a court order. So you really have to start that court process before you're going to get any sort of potential enforcement help. But we're finding that even when you have a court order that's been entered, like a permanent injunction, that you still can't really get the police department to come out and enforce it until after there's been a contempt order issued. And that only happens after, you have the permanent injunction. You have to go through this whole process, which can take months. Then you get a contempt order issued, You have to go to a long, big hearing and prove up all this evidence on contempt. You finally get the contempt order issued, and then you may be able to get some enforcement help. But it's only after a lot of time has passed. So these are really big issues for a board who is trying to protect a resource. And a lot of times what we're seeing is that by the time we get there to that contempt order, that the land has been plundered. And there's also been some issues with just the lack of education and understanding with regard to law enforcement, where I've had law enforcement officials tell me specifically that the board has no authority to tell an heir not to remove resources from the land grant. If, as you can see from the statutory provisions that we discussed previously, that's absolutely not the case, but that is a misconception. So these are just some really large issues that we need to address in some way. And what it means is that the obligation to document and pursue a violation is completely left on the shoulders of 5 individuals who basically are barely paid. And I also want to mention that one of the things that's not addressed or not discussed often is the emotional and psychological toll that it takes to go through this litigation on the members of a board, especially where a lot of times because of lack of education, there can be a lot of personal attacks on the members of the board. So next slide. Okay, so the third issue is that we do have this civil enforcement authority. However, it's such a difficult process to go through. So this is kind of hinging on what I had said previously, but the board can file a civil complaint, and generally the type of relief you're looking at are injunctive relief, which is basically the power to force somebody to do something or stop doing something. So for instance, this would be like, you've heard of a restraining order. A restraining order is a temporary restraining order, but there's basically more permanent versions of that, like a permanent injunction, which is say you can't remove resources from the land grant. So that would be an example of injunctive relief. You can also seek damages, which is repayment for what has actually been taken or removed from the land grant or the damage to the property. But there are issues with both of those things. So let's move on to the next slide. So for injunctive relief, you have to show, in order to get injunctive relief from the court, you have to show that irreparable harm is going to occur if they don't allow an injunction to be issued before a final resolution of the case. So if they think, for instance, that the damages are something that you can prove up later and get compensated for in money damages, you may have a difficult time actually getting an injunction. Also, it's really showing that the timing is important. I have had success in getting injunctions in these cases, but at the same time, it's a high bar that someone has to pass to obtain that injunctive relief. Also, the other portion of that is that you have to show that there are not other legal remedies that would be adequate to assist in the situation. For instance, like a writ of restitution, where you can go take back sand and gravel or rock product or timber, or whatever it might be, from someone who has taken it wrongfully. And then you have to also show that there's, and I think it said some likelihood, it should say a substantial likelihood of success on the merits. So it's really kind of a difficult thing to prove, and you need to have some real strong evidence to support that in order to get injunctive relief. Okay, next slide. Okay, so perhaps the more challenging part of it is actually showing what the damages are. As I expressed before, by the time you get to court, you have a certain amount of damages that have occurred, but how are you going to quantify what those damages are on a land grant. Usually that's going to require an expert witness to come out and say, well, this is what we think would be the cost to bring this land back into the condition that it was previously. Well, how can you do that with a land grant where you may not know what was there prior to the removal of the natural resources? And the next slide actually just has some questions. These are real questions that have come up. So how much of the resource was removed? When was it taken and where from? What dates was it taken on? These are things you actually have to prove up in court. Who witnessed the removal of the resource for each separate violation? Now, if you have someone that's going in there daily, imagine how hard that is to prove. Could someone else have been responsible for taking the resource other than the person being sued? If you have a picture of a vehicle, but you don't have the person who's inside it, who do you know who's driving it? How many different violations occurred? How much does that type of resource typically sell for? Alternatively, how much is the value of the land decreased? How do you value community property in a land grant? It's just very extensive, the number of questions and the proof you have to go through in order to actually obtain damages in these cases. So I'll let you kind of look at those, but it's just very burdensome. Okay, next slide. Okay, so the other thing I wanted to mention is just the attorney's fees and court costs are often cost prohibitive. You have to have an attorney if you're a land grant because any entity has to be represented by counsel, and just one member of the land grant is not allowed to represent everyone in the land grant, and that is done to kind of protect the rights of all the individual people within the land grant. But at the same time, it means that it's going to cost the land grant a lot of money to address these issues. And I said estimated attorney's fees and court costs, I should mention, $25,000 to $50,000 per year that the case is in litigation. That can be a quick process or a very long process. You have to consider that a defendant has a right to appeal. If you had filed a smaller case in magistrate court, then on appeal, the type of review is de novo, which means that they get a new trial. And so you have to go through the whole proceeding again once you get to the district court. And then it could be appealed again in the district court, although the standard there is you have to show some sort of actual legal error. So basically what it comes down to is that it's only worthwhile to prosecute the most egregious cases. Which is unfortunate because I think a lot of the time, if you could catch someone when they've only violated once and they could be fined in some way and you could enforce it quickly, you might be able to stop it from getting completely out of control. But I wanted to mention we have also tried doing limited actions just for the permit assessments. So basically, this is where the board would kind of overlook the fact that they had maybe not completely complied with what would have been in a permit and they had gone and taken something without a permit. And then they say, well, we'll allow you to purchase retroactively your permit going back for these years, and then we'll just drop the claim for the damages. Well, that's easier to prove because with assessments, you're going to have a paper trail that shows this is the amount of assessments that were due, or this person didn't pay any assessments. However, it's not fair because if you prosecute one person and you go after them for damages, you might get, for instance, $1 million judgment against them. And then if you go after them for assessments only, you're going to get maybe $2,000 or $3,000 for many years of violations. So who do you prosecute in those cases? And is that fair? And is that going to potentially lead to due process concerns? So I think that is another issue that we kind of face with regard to this. Next slide, please. So the other part of this is that once you have an actual final judgment, you're past the point of appeal, you still have to actually collect on that judgment. and enforce the injunction if there's an injunction in place. Police departments, again, are hesitant to enforce civil court orders unless there's been a contempt order issued. And in addition, each of these steps the board has to take to enforce a judgment costs more money. And then there's also another issue of many of the violators are what we call judgment proof. And when someone is judgment proof, it means that you can get a judgment against them, but you'll never be able to collect on it because they just don't have the resources to pay out on that judgment, or the resources that they do have are exempt. There are certain legal exemptions to collection from being collected. So that's another issue that the land grant faces. And that's very common because we have a lot of people who don't have a lot of resources who reside on the land grant. And I also want to mention, this is not just against heirs, this is against non-heirs as well. All of this pertains to the same, but you still have the same issues regardless. Okay, next slide. Okay, so now here's the brainstorming portion of my presentation, which is just some ideas I have come up with personally. It doesn't mean these are great ideas. It doesn't mean I'm saying we should do this. I'm just bringing them up so that everybody can discuss these potential solutions. Next slide. So before I go into that, I think that, and even what I have drafted probably doesn't do this, but some of the goals that you should always do when you're thinking about legislation is to only legislate what you need to legislate. So address only the things that you need to and let the land grants address what they can through adoption of their bylaws. Ensure that the legislation is practical on the ground and mirror other legal provisions that have already been drafted and successfully implemented where it's possible. You need to consult with experts to ensure that the new provisions vibe well with existing law and think about how the proposed, this is actually kind of a nice portion of this, is if you can think about ways that the proposed legislation can actually be tied in to create additional economic opportunities and maybe job creation on the land grant. So that's just something else that I wanted to mention. Next slide. So here's one of my suggestions, is to allow the board to have some criminal prosecutorial authority. So what I would suggest, or what I would, and one thought I've had, I don't know if I suggest it yet, but it's a thought I've had, is to amend 4911 to just allow the issuance of a citation or something like it, maybe some new thing, by the board in place of arrest for a criminal violation. So basically, you could make that what's called prima facie evidence that a violation occurred. And that would help to resolve issues of trying to get law enforcement out to a land grant to file a police report and that sort of thing, because basically it would put that responsibility into the hands of the board, who's already doing it anyway, but it would be something that would be binding when you went into the court process, and the other side would have to then rebut the fact that they have been accused of removing resources from the land grant. It helps also to eliminate, let's see, hold on one second. Yeah, okay, so that's fine, but that's all I had to say on that. The other thing we could do is make the illegal removal of resources from a land grant a misdemeanor under the criminal code, and provide up to 6 months of jail time and/or fines paid to the state for theft of natural resources. Now, I think that's great, but if nobody's going to enforce that provision, it's not great. So there needs, this is a recurring problem of just trying to find somebody who has the power, the time, and the ability to enforce some of these things. And the reason I put 6 months of jail time in here is because I believe that is the cutoff for both legal counsel, the requirement that someone receives legal counsel. It could be less than 6 months. It could be, you know, 30 days. It could, I think jail time might be better than fines in some ways, just because it really gets someone's attention. A lot of people might not even be able to pay the fines. But basically, I think that the 6 months is also, you know, the cutoff point for a misdemeanor offense. I'm not a criminal attorney. I don't purport to be. So if I'm incorrect and anybody wants to correct me, I'd be glad to take their advice. Also, if there are certain cases in which the board could prosecute, you know, certain things, it could just be maybe the failure to pay assessments without counsel in the magistrate court proceeding. I think that might be helpful. And there is some precedent for that being done in acequia associations with regard to payment of assessments. They allow the mayordomo there to go in and prosecute non-payment of assessments. Okay, next slide. And these are the additional civil remedies that I've come up with. I'm going to kind of rush through a little bit of this because I know we want to get to questions. But basically, you could create new statutory provisions that allow civil remedies for theft of natural resources. You could allow attorney's fees to be collected. You could create a civil penalty that's payable to the land grant itself. That could be either in addition to or in lieu of proving up the damages in these cases. These are things that would need to be considered by a criminal attorney and also in light of due process. But these are just some thoughts I had. There are, as I said, there are other areas where there's been civil penalties along with criminal penalties that have been allowed, and I've provided you folks with a copy of 7325, which is another acequia statute that allows for basically prosecution of someone who is in violation of easement rights for an acequia. So that's something to maybe look at and think about, and then try to create some sort of legal defense fund is another potential issue or another potential idea. Sorry, next slide. Okay, and on the enforcement issues, this is just somewhere where we need to do a lot of work, and I would encourage the council to maybe create a committee to work on this issue. Basically, I don't know if citations would work, which I had mentioned previously, but if this board were allowed to issue a citation, then they could maybe hire staff to help patrol the land grant and issue those citations and take that responsibility away from law enforcement. You could also delegate enforcement authority for enforcing a judgment to a particular agency who already has policing powers, and then provide funding to that agency with a specific purpose of helping land grants with protection of natural resource issues. And then the last thing is just to provide, as part of that, I would highly recommend providing some education to any enforcement agency considering the operation and management of land grants. And that's basically it. I also provided you I took some of the existing statutory provisions and put those into a handout just to show you how some things could be kind of drafted. That's just for you to think about and look at. So did anybody have any questions, comments? That's a long presentation.
No, that was great. Thank you very much. First of all, is Senator Baca on the line so he could introduce himself? Okay, Representative Alicia Alcon, you have your hand up. Representative Alcon, are you there with a question? Okay, is there any other committee member that has a question or a comment? Representative
Yes, Madam Chair, thank you. I guess my question is to Mark. Mark, on Andrea's presentation, or on her proposal in terms of maybe some legislative fixes, how do they differ or how do they complement what we've been doing on this natural resource officer legislation based on what's going on in the Anton Chico grant? Are there similarities there, or is what Andrea proposing kind of different? What's your take, Mark?
Madam Chair, Representative, my take is that what Andrea has put together avoids the question of creating a legal officer that is employed by the land grant itself. That's what had been proposed last year. There were questions about what sort of liability that would raise for land grants that had their own law enforcement officers. But there was also a question, Anton Chico had wanted to use a retired law enforcement officer that is a member of the grant who is offered to volunteer his time, but he wanted to be compensated if he was hurt on the job. And I just didn't understand, and I haven't yet to figure out, I haven't found anybody that understands the mechanics of workers' comp to make that feasible program, because workers' comp is usually tied to how much you're actually making or what your salaried position is. But if your salary is zero, I'm not sure how they would figure out workers' comp. I don't believe Andrea is trying to go there. That's the way I see the difference. One thing that was of interest in Andrea's presentation is making the violations a misdemeanor with some sort of strict liability for damage to the land. That would still be up to the county sheriff to enforce it, but it does have a nice trigger mechanism as far as, if someone is legally at fault or not.
Yeah. Well, thank you for that, Mark. And thank you, Madam Chair. That's all I have.
Thank you, Representative Garcia. Representative Alcone, did you have your hand up? Okay, Representative Salazar.
Okay, Madam Chair. It took me a second to push the button. And you were too fast for me. My comment is on the misdemeanor charge, state statute. Having been an ex-magistrate judge, the statutes say that a misdemeanor is punishable with up to 364 days of jail. So if you're going to go misdemeanor, it's going to be 364 days jail. So I'm trying to do two meetings at the same time, okay? So forgive me for that. But the other thing is, what I had mentioned before, that if you look at and I've talked about this before, if you look at the statutes referencing the acequia gives the mayordomo the right to proceed in magistrate court without having to pay fines or fees or anything like that. So you might want to look at, again, like I've mentioned before, you might want to look at the acequia rules and kind of follow and see if you can follow those statutes. This allows the mayordomo and the acequia can file in magistrate court without paying any fees and prosecute. So you can change that to where the president or whoever the designee is of the land grant board to do the prosecution and follow through as far as court proceedings are concerned. Just a couple of comments. Thank you, Madam Chair.
Thank you very much, Representative Alcon. There might be some possibilities. Andrea, did you want to comment on whether you had looked at that?
Yeah, I have looked at those statutes. I don't have them in front currently, but yes, I did look at that. That's one of the, I think in what I had put together in this little drafted proposal, I had basically taken some language from the acequia statutes that allow a mayordomo to prosecute, it's assessment, so it's for non-payment of fees to the acequia. The mayordomo and the magistrate court only can file and prosecute those cases. So I did take some of the language from there and try to put it into a proposal. Also, I did look at, and that is actually, I work with a lot of acequias as well, so that's kind of the reason why I think this came to mind for me, is because I know that those exist in the code for the statutes for acequias. So yeah.
Yeah, again, not only is the mayordomo allowed to prosecute in magistrate court for fines and fees, but they also are allowed to take cases into magistrate court that are in violation of a acequia law. In other words, if you break or you dam up the place, or you whatever process that you do as far as the water rights are concerned, those can be taken to magistrate court to be handled there, and they can be handled either civilly or criminally. So it's something to look at. It's so hard to follow through, but that's why I'm such an old man. Thank you, Madam Chair.
Oh, Madam Chair, I'm sorry, I can't hear you. I hope you can hear. Can you hear me? Okay, so all I was going to say is that I lost my train of thought. The one issue with there's two issues with magistrate court, which is that it's an appealable de novo, which means new trial in court, and the other problem is the jurisdictional limits of $10,000 in damages, and they can't, where there's property boundaries that are going to be in dispute, they can't potentially in the litigation they can't try those issues. So with natural resource protection cross county, that could potentially be an issue. I just wanted to mention that as well.
Okay, thank you. Anything else, Representative Alcon?
I'm done. Thank you, Madam Chair. Thank you, Madam Chair.
Thank you, Representative Tomas. Thank you, Representative Tomas Salazar.
Thank you, Madam Chair. I did see Mark Edwards raising his hand, Madam Chair. I don't know if he had something to contribute before I start.
Mark, did you have something?
Yes, Madam Chair. I wanted to point out that I've drafted a number of misdemeanor statutes in our traffic code where the legislature has specified like a fine up to a certain amount. It can be then the maximum amount for a misdemeanor. And I assume you could do the same thing with regard to jail time. You could say up to 30 days, for example. It wouldn't have to be for the entire misdemeanor amount, which is generally up to almost a year.
Okay. Thank you. So Representative Tomas Salazar, let's go on to you, please.
Thank you, Madam Chair. And yeah, I really enjoyed your presentation. It does give us, at least it gives me a lot to think about. I think in part, these are comments and probably do not or may not require response, but sort of like the things that I think about are things of the following type. And although I think you go much further in terms of your suggestions, and you do make reference very much to kind of statute-specific recommendations that you think probably would be useful. But the first thing that entered my mind is the little that I know about the Land Grant Council and what it is that they do. I do know that they sort of work with land grants in terms of legal services for land grants. Now, I think, again, and to your credit, I believe that in one of your slides, I think it's slide 18, you do make reference, for example, the idea of providing a connection to things like the UM Law Clinic, New Mexico Legal Aid, and we know how much legal aid help we get and so on, which is phenomenal. But I think in particular, the one item that I sort of thought about almost immediately was the Land Grant Council and how much of an intersection there would be. If I recall correctly, the Land Grant Council, somebody might be able to correct this on me immediately, I believe falls under the executive department. I don't know if that's an issue at all, but I think it's certainly something to think about. But again, Andrea, thank you very much for your presentation, and thank you, Madam Chair.
Thank you. And let's see. Do we have any other hands raised, Mark or Sarah? I think
I don't
that's
see any, Madam Chair.
okay. Thank you. Thank you very much, Andrea, for coming to share some of these ideas. And if the committee wants to pursue any of them, they will bring it up. Okay. Thank you.
Thank you very much.
Okay. So we are now going on to item 7, the Tierra Maria Land Grant Merced status update and legislative proposal. We have Steve, Lisa, and Arturo presenting. So who's going to start?
Madam Chair, that'll be me,
Okay.
Arturo. So,
Well, welcome. And I know, Arturo, you have other items to bring up in public comment. So we'll wait for that time and just focus on this.
yes, thank you, Madam Chair, members of the committee. Buenas tardes de Dios. Good afternoon to you all. Thank you for the opportunity to present. Today, we're going to be kind of discussing issues related to traditional uses and the potential return of about 44,000 acres of common lands to the land grant that's currently managed by the state Department of Game and Fish, owned by the state Game Commission. And so the way we're going to do the presentation is we're going to give you guys a history of kind of the history of the land grant and some of the injustices that they faced. I'm going to cover the first 100 years, and then Steve's going to cover the next 100 years up to current, and then Steve Polaco, who's the president of the land grant, and then Lisa Martinez, who's the secretary of the land grant, is going to kind of talk about a proposal for traditional uses and why that's important. So we do have an actual presentation. I don't know if Sarah can pull that up. Yes, and you can go ahead and you can go right there. Perfect. So just to give you guys a brief kind of overview of the land grant itself and the resources, the Tierra Maria land grant, as patented, was 594,515 acres of common land, or in total, and that included in that about 10,000 acres of the original private parcels within the grant, and those private parcels were entitled to use of the commons for natural resources, which we'll kind of go over. So, those hijuelas make up only about 2% of the total common lands that were granted to the original families who settled in that community beginning in the 1830s. And today, they currently hold 0 common lands. As you heard earlier, we're hopeful that if we're able to raise the 40,000 needed to enter into that settlement agreement, they'll be able to regain those 200 acres. And then if we can successfully engage the Game and Fish Department in this negotiation to return the Laguna del Campo, that'll also net them about another 20 acres back to the land grants management. And I think it's important to note that in the last presentation, it is a land grants are able to manage those common lands. We have evidence of it for those that still maintain common lands and do so. The largest being Anton Chico with over 100,000 acres of land. So it is possible. It does have its challenges, but I think it's important that is kind of something that's mentioned. And so if you can go ahead to the next slide. You can skip to the next 2 slides, actually. Yeah, you can skip that one. So the land grant petitions for the land grant actually started as early as 1814. There was 4 different petitions to first the Crown of Spain, 2 during the Spanish period, 2 during the Mexican period, from community members from Abiquiu. As you know, Abiquiu is a Genízaro grant that was settled in the 1700s, 1758. As that community grew, and it was the surrounding commons were not enough to sustain the community. Individuals petitioned and community members petitioned the government for new grants further to the north. And Tierra Maria was one of those. Every single one of those petitions starting in 1814 included what is known as a poblador principal, or kind of the primary petitioner, primary settler, who petitioned on behalf. In this case, there was actually, in the first 3 petitions, there was 2 individuals along with other families. The first petition had 72 people that petitioned for it. The second one had about 62 individuals. Then there was another, that was in 1820. And then in 1824, you had about 80 families that petitioned. And then in 1832, the one that actually gets granted, that one also had Manuel Martinez as the primary petitioner, but along with other families that would accompany him on that journey. And so it's important to kind of note that during that period, you have the beginning of the independence movement in Spain, where Mexico gains independence. We see this in other land grants like Manzano, where they kind of start the process to get a grant during the Spanish period, but it's not completed until later in the Mexican period, after kind of the dust settles on that independence movement. So in 1832, the Royal Deputation, which is kind of the agent of the Mexican government that's issuing grants at the time, issues a grant to Manuel Martinez and the others who will accompany him, including his children, up to settle that area. And in that grant, it is very clear that it is a community grant. There was some discussion early on and some back and forth between the Ayudamiento, which is like the local town council, and their report to ensure that it includes common waters, common pastures, and common road access for all of the settlers, as is tradition. And so the deputation grant itself actually states that the waters, pastures, and roads will remain free of use for the settlement. In 1844, so 1832, it's granted, and settlement kind of begins from that point on. And there had been attempts to sort of settle the area, but they're met with challenges, and so permanent settlement kind of is coming in waves. They'll get there, they'll settle, they'll have some rough winters, they have some skirmishes with some of the tribes that are there, and so it's kind of off and on and spotty. And in 1844, Manuel Martinez, one of the original petitioners, actually passes away. 1848, as you guys know, the Treaty of Guadalupe Hidalgo is issued, the Mexican-American War ends, and there's a process put in place for land grant communities to petition for recognition of their land claims. And in 1856, Francisco Martinez, who is the son of Manuel Martinez, submits a petition to the Surveyor General claiming ownership of the grant, or seeking to get recognition of the grant. And you can go to the next slide. So it's one of the first ones that kind of actually goes through the process. And the very first Surveyor General of New Mexico, Pelham, recommends approval of the grant, and in his notes, on his approval notes to Congress, he does recognize the fact that the pastures, watering places, and roads are to remain free and common. He actually pulls that language directly from the granting documentation, and he recommends approval to it in 1856. So it's submitted in July. of 1856. By September of 1856, he submits a report to Congress recommending its approval. Congress takes several years to actually make the approval, and it's not until 1860 that Congress approves the claim. It's actually land grant claim number 3, so it's only the third one that is approved in the state. By that time, you already have some land speculators who are kind of moving into New Mexico and looking to take advantage of the opportunities that may bring in terms of exploitation of some of these land grants. Francisco Martinez, simultaneous with the approval by Congress, he treats the grant as though it's still the same under the customs of Spain and Mexico, and that is to say, he issues deeds, which are known as hijuelas, to approximately 132 families on the grant, or not approximately, but actually 132 families that we're aware of on the grant. And it's common practice. Again, it's the deeds of possession, which basically are the barras of land, small plots that are for private use, but those ownership entitles you to use of the commons for sustaining yourself in the community. And so these 132 families that receive hijuelas, it's between the period of 1860 to 1865. Those are all recorded in the courthouse, the Rio Grande County Courthouse. You can go today to look at those deeds and hijuelas. And they include language that guarantees the rights to free access to the common lands for pasture, water, firewood to heat their homes, timber as a building material, and roads. And those 132 families are actually spread out through 7 distinct communities. They include the community of Nutritas, which is now known as Tierra Maria, Los Ojos, Los Brazos, Ensenada, La Puente, Barranco, and Cañones. And so those are the original settlements. So you see, it's not just 1 or 2 communities that settled, but multiple communities with over 100 families that are settling there on the grant. You can go to the next slide. So in 1874, Francisco Martinez passes away. And so this is, 14 years after the grant. It's approximately 10 years after he's issued these deeds to the community. That process kind of still continues if new folks kind of come in. But with the passing of Francisco Martinez, you see immediately that Thomas B. Catron, who you guys are on the committee are familiar with, a notorious kind of leader of the Santa Fe ring, a corrupt politician here in New Mexico, and a land speculator who ends up owning vast swaths of land with interest in, I think, about 23 different land grants during his lifetime. And so he and his associates immediately began to acquire interest in the land grant from the heirs of Francisco Martinez. So they go to Francisco Martinez's children, and they began to acquire his interest in the grant. And this is an important point because at this point in time, we still don't have a patent issued, right? So we have an approval by Congress that the grant was valid, but we don't have an official patent. And even though the first Surveyor General is the one who made the recommendation, it's like the 4th or 5th Surveyor General who actually undertakes the process of doing the patent. And this is a gentleman known as Henry Atkinson. And Henry Atkinson is a known corrupted U.S. official. He's one of 3 Surveyor Generals who were dabbling in land speculation, part of the Gilded Age, and was a known associate and business partner of Thomas Catron. In fact, they're the ones who defrauded the Alto Chico land grant of a vast majority of their common lands. And so the Surveyor General in 1876 begins the process of surveying the grant based on the description, and they find that it contains 594,515 acres of land. And Thomas Catron then works with the Surveyor General to get the patent issued in the name of Francisco Martinez, his heirs and assigns, and makes no mention of any of the other original petitioners, even though the granting documentation does state that there are going to be others that settle. And we know that these deeds that are issued specifically name who those other settlers are, those 132 families. So, roughly 500 to 600 probably different individuals living on the grant. Next slide. So the patent's issued in 1881. So that's a 21-year period that spans from the time that it's approved a 25-year period from the time that it's petitioned and the Surveyor General makes a recommendation to when it actually receives a patent. And again, the patent is issued just solely in the name of Francisco Martinez, who has already passed away by this time. He's already been dead for 7 years by the time the patent is issued. And in 1883, Thomas B. Catron files a quiet title suit against the heirs of Francisco Martinez for the ownership of the grant. And he only names the heirs. He doesn't name any of the other community residents who were settled there in 1883, which might, by this point, maybe more in terms of the actual number of people as the population grows. And we know that this is part of the Santa Fe ring structure. We know that the court system was set up against, at that time, the judges, the territorial judges that are appointed. They're part of this land speculation schemes. They themselves are usually involved. And so it was really kind of set up against them. It's unclear as to whether or not the community received due process, since they were not listed or named, if they were even aware that the suit took place. And that's something that we're kind of further in doing some further investigative research on. But as far as the community is concerned, they continue to use the common lands. They continue to, after all, they have hijuelas, they have deeds that actually entitle them to all those uses of the common lands. So they continue to use it unabated. And then Thomas Catron, he initially does some land speculation deals, including starting a lease for the railroad. You guys know it now as the Cumbres and Toltec. That was part of the Denver and Rio Grande Railroad. At the time, he starts some timber companies. Not too successful, but he keeps the grant intact. So the common lands are still intact in its entirety. And what you have happen is his son, he deeds the property over to his son. And he also has some holdings in some companies that he owns. And in 1909, his son and the companies began transferring all interest in the land grant to the Arlington Land Company. You can go to the next slide. And the Arlington Land Company is actually a company owned by some Midwest financiers, including a U.S. congressman and Angus. And that company begins to break up the land and sell it to individual and other interests. So it's other land companies. Thomas Burns, who is a local mercantile who's married into the community. He acquires about 70,000 acres of land. And so it's from this breakup of the common lands that you see that's where the chain of title from the Sargents, Humphreys, and the Rio Chama wildlife management areas all stem from that breakup. And so they all are part of the original common lands. And it's after that period that you begin to see the community realize that the land's been taken as new individuals come in and start fencing off properties and removing cattle that belongs to the community, common pastures, denying their access for using, for getting fuel wood and those type of things. And next slide. So with this, I'm going to pass the baton over to Steve. So Steve, if you can turn on your camera and your microphone. And Steve's going to kind of take you through this gets you basically to the 1920s, and Steve will cover the next kind of 100 years and some of the struggle and injustice that the community faced as a direct result of the way that the common lands were kind of swindled away from the community. Steve, are you out there?
Yes. Can you hear me?
Yes.
Hello. Thank you for giving me the opportunity to present this to you. Thank you, Madam Chair, members of the Commission. I'm happy to see you again. It's been a while since we've seen you. And buenas tardes, Dios, and God guide us in the right direction and keep us firm and steadfast in what we're doing. I would like to start off starting with Ed Sargent and T.D. Burns, who at that time start entering sheep and cattle sharing agreements with the local settlers, which is in Spanish known as partido. And by interest of the land grant, not telling settlers that they were the new owners of the common lands. Settlers continue and had always been continuing to use the common lands, not knowing what had happened, herding the sheep, raising the sheep on these properties. And when the fall would come in, when they would bring the sheep in for market, stories have been told by numerous elders in our community that who were involved in these agreements that most of their sheep or cattle had died. So, but Ed Sargent's and T.D. Burns' sheep survived. So this would put them in debt with the T.D. Burns and Ed Sargent agreements. So they would have to pay for extra for the loss that they had with the sheep and cattle. So this was unjust, and the people were really getting concerned about that. And so later on, after that was in the 1920s and 1945 in that area. A lot of people were really getting disturbed about that. So then in 1950s, well, from the 45s to the 50s, Ed Sargent, T.D. Burns, and the Spill brothers, Ed Spill, began to fence off the common lands. When they were doing this, people were really concerned about this and didn't understand why they were fencing off their lands, which they had believed that was theirs for since their inception, and came into the TA grant and was guaranteed by the not only the Huelas but the Treaty of Guadalupe Hidalgo. Can you go to the next slide, please? So people were so concerned that at that time there was the men and some of the from some of the villages would gather, and they would have meetings at the moradas in the areas, and it was a secret organization called La Mano Negra. The Mano Negra were consisted of these men who would plan a strategy how to resist the influx of these occupiers, and they would on one night they would conduct raids, cutting hundreds of miles of fences and burning haystacks which belonged to these encroachers. That was their example of trying to show a resistance. They were incredible. They would just cut these fences in small sections and tear down posts all in one night. And some of the stories I heard from all of the older people who are not here anymore, they talk about how exciting it was for them to do it, and they were going to really show these people, and then they would run them off. They would have to run them off, but there was no violence other than that. And then later after that, after the 50s, around 1956, they organized a board of trustees of the TA grant and gathered monies throughout the community to send the board of trustees to Washington, D.C. to inform and complain about the happenings on their land, to their land grant to Senator Dennis Chavez. Well, they explained everything to Dennis Chavez. I found a letter that is in detail. It's all written in Spanish. And the three representatives, ironically and surprising to me, at that time, my grandfather, Enetro Velasquez, was the president. And the vice president was Jose Maria Martinez. And the secretary was Velasquez. So they went into Dennis Chavez's office to explain, and they got a response from Mr. Chavez that, hey, you need to go find a representative somewhere else. You can't be here. Just get out of my face. He told it to him in Spanish, quítame de encima, and that means get out of my face. So can you move to the next slide, please? So they came home and they were lost. They didn't know what to do. So the community, in accordance with state law, gets approval from Rio County to conduct an election board of trustees, which everybody was really hyped up, and they were going to finally get recognition but the election was stopped by a lawsuit filed by out-of-state companies that had bought from the Ketchikan and Arlington chain of title. This was a real big upset for them because they thought finally they were going to be recognized and they were going to move on the road. So it really brought them down. And so then right after that, in the 50s, a hired person named Bill Mundy, who came up from the Hatch area, comes up and he starts working for the T.D. Burns and Ketchikan part of that Santa Fe Ring and organization, and begins to gather cattle that was grazing on the common lands, and holds the cattle and sheep in common in corrals and begin to charge settlers for grazing. I can remember as a small boy that my great uncles were talking about that issue, and their father, my great grandfather, had told them that to go out and bring the cattle in, and when they brought the cattle in, they said they couldn't find the steers, and the steers and were nowhere to be found. So they went out, they gathered up with the rest of the men, and they all went out and they had an idea where it was, and they found all the steers in corrals. And there was a confrontation at that time, and I don't know what happened because at that time my great uncles told me to leave the room. So then the land grant community files several lawsuits seeking justice from the courts, and the justice denied those files that they were seeking. Can you move to the next slide, please? Okay, the settlers in the early 50s were being told and warned not to be on common lands and the cattle drive roads known as callejones. Men, women, and children who were tending to their cattle and flocks of sheep or the gathering of fuel wood, choke cherries, herbs were threatened at gunpoint because they were trespassing. They were practicing the rights that were to be inviolably respected as a result of the Terra Maria land grant patent and the descriptive rights of the Ayuhuelas, which was in between the 1950s and 1990s. Later on, companies like the Payne Land and Livestock Company and Mundy Inc. began to file in federal court lawsuits against the claimants who were issued life estates by the courts. The claimants were told by their attorneys that the lands belonged to them, and now they could go home and carry on with their lives. This happened in a lawsuit in 1956 that my grandfather was involved in, and my grandfather and the others had no idea what the meaning of a life estate was. Furthermore, they never signed any such agreements. The documents showed an X in my grandfather's signature, and my grandfather was literate. He knew how to write. He didn't know how to write in English, but he knew how to write his name. So that was a big issue for my family. And at that time, we were suspicious of us. And lo and behold, we get a order from the court saying that we were being sued by Payne Land and Livestock Company and Mundy. So we went to court, and we showed that there was. We went to several courts, and the first court was in district court in Bernalillo with Judge Perez, and he held that we won that case because my grandmother was never named in the suit. And that was another thing. A lot of the claimants were only identified as the male person, and they were married, and those spouses were never even named in those suits. So we won that case because of that issue. So then the Mundys appealed to the appellate court, and the appellate court decided that the life estate prevailed. And so we were stunned. Our attorneys were stunned. We gathered. My family gathered in California, my uncle's house, and this was in 1974. and we decided to let's go and pretend and protect what is ours. So we came out here and we stayed here and we had arms. We had the community behind us. We were ready for confrontation. We were willing to go. If we were going to die, we were going to die in our land. Then after that, we had the Rio Arriba County Courthouse raid in 1967, and everybody knows about the Rio Arriba County Courthouse raid, where there were lives taken. There was some meetings of some of the elderly people who were trying to organize for the land grant, and the authorities thought that they were illegal gatherings, and so they started to arrest them. And there was retaliation from the local communities, and they wanted to have an arrest on the district attorney. So they went in, and something happened, and it just exploded, and people were injured very badly, killed, and it was turned out to be a real bad thing. So can you go to the next chart, please? Around that time in 1968, the New Mexico Department of Game and Fish Commission began to purchase the Humphreys, Sargents, and Rio Chama properties. Now you have to understand, in that area there was all kinds of things going on, and the issues were happening, and the Department of Game and Fish, I'm sure, was well aware of all the issues of the land and the claims that the communities had. So they start buying up these properties. And that's when they start setting restrictions on the heirs of the communities not to enter the Humphrey Sargents and the Rio Chama properties. This was happening around 1968. Then, in 1980s, the Ganados del Valle, which is a nonprofit group from Los Ojos and the community, attempts to graze sheep on the Humphreys, but were denied. They were told that the grazing of the sheep would deplete the grasses and feed for the wildlife. So that ended there. And then after that, I just now explained the lawsuit with the Pain Land and Livestock Company against my grandfather, Netro Velasquez, in 1974. I kind of jumped the gun there, but I had already explained that. So then we go on into the 1980s, where these companies, LLCs, known as the Tierra Grande, the Ensenada Resources, and Chama Enterprises, hire guards to protect and prevent heirs from entering onto the common lands in the Ensenada area. I was personally involved where I was coming home at one time on the county road, and I noticed that there was a backhoe excavating along the county road. And I got off and I asked the person who was there, who I thought was my friend, but later I found out he was one of the guards. He told me that they didn't want people coming into the property anymore, and he started getting really physical, and he came up to me and grabbed me, and it turned out to be a fight. So we got into a fist fight, and then I didn't want to hurt the guy, but I left it at that, and later on I found out that the Ensenada Resources in Tierra Grande had filed a suit against me. Can we go to the next slide, please? After that, all of these things were starting to happen again. The Wheeler case was involving a Cajon over by the Los Ojos cemetery. That was a cattle drive that was used by the community to take cattle out to the commons, which extended from Taos all the way to the Continental Divide and almost all the way to the Chickadee Reservation, which is known as the Stagecoach Road. This road was and Cajon had been traveled and used since the 1814s. And then there was another incident where El Callejón de Cañón de Roque also known as Camino de los Pobladores, was a cattle drive route. And the Cañón del Roque is what is now the Humphreys. So out in that was prime land for grazing because the grass was tall, as high as the belly of a horse. There was just open fields, and there was plenty of it was proper. It was ideal for grazing. And so, excuse me. Then later on, there was the Vista de los Brazos versus the Armador Flores, which everybody knows was the famous Flores case. Flores claim on common lands and wins the case, turning land over to the community land grant heirs who formed the Consejo to manage the property in 1988 and 1989. Can you switch to the next, please? So all of these things are happening. All of these incidents are happening. It never stopped. It still hasn't stopped. I'm a barber, and I was cutting this gentleman's grandson's hair just a couple of days ago, and we were talking about the land grant and the development. And he tells me that his grandson was walking up the county road up into the area where Tierra Grande and Ensenada Resources and all these companies have property. And he was on the county road, and this person comes out, an elderly man, probably in his 30s or 40s, and tells the boy, what's he doing? And this boy is only 13 years old. And the boy says, I'm walking. He says, well, I don't want you to walk out here anymore. And he had a gun. He says, if you come out here again, I'm going to shoot you. So he was really freaked out about that. Another time, I was cutting another person's hair named Vicente Montaño. He was telling me about the T.D. Burns and his tactics of El Partido, where when they brought their sheep in, all of their sheep had died, but all of Burns's cattle sheep were alive. You know, why did that happen? So all these stories, there's a lot of people around here who have all these stories, all the stories that of all the older people who had already passed. It's all the same. It's all the same. Nothing has changed, and we've always been losing on ground on our common lands. These developers are coming out here. They're taking over. They're threatening us. It's a terrible situation. Thank you. Lisa, I think I'm going to hand this over to Lisa Martinez now.
Okay, Lisa, we're ready.
Awesome. Thank you. Good afternoon, Madam Chairman, Chairwoman, and the members of the committee. So I would like to direct your attention to the quote that is on your screen. On the 20th day of July, 1832, the most excellent territorial deputation granted to Manuel Martinez and those who should accompany him, the land petitioned for under certain conditions therein contained, and directed the constitutional justice of Abiquiu to place the parties in possession of the land so granted, leaving the pastures, watering places, and roads free according to the customs existing in every settlement. Take that in for a second. And what stands out to me is the land so granted, leaving the pastures, watering place, and roads free according to the customs existing in every settlement. So I imagine that our ancestors thought that it was going to be the beginning of what would be a fruitful life. Surely they may have imagined there would be ups and downs and tough winters, hot and dry summers, but nothing like we've seen in 206 years of the struggle. Next slide, please, Mark or Sarah. The land that we've fought for, or that they've fought for, has been stolen, has been sold, and has been lost piece by piece. And their people have been left without the rights or promised. La lucha 206, 206 años de lucha. Zero land to show for that struggle. I mean, we see every day the land that our ancestors fought for, drew arms for, and died for. Tierra o muerte. Y para qué? For what? 594,515 acres lost to the hands of ladrones and thieves, as our history has shown, and how Steve and Arturo have just taken you through that. We are reaching a new season, though. And I'm not talking about the fall, and I'm not talking about the winter that's coming up. I'm talking about a season where our people are tired of being victimized and taken advantage of. We are entering a new fight. We are taking up a new lucha. And I imagine this lucha doesn't look like the one that was before, because in place of weapons, we are bringing law, and in place of raids, we are coming together as friends and family, and as the strong people we know ourselves to be. We are who our ancestors left behind. Next slide, please. And you can skip over this one. Thank you. So pastures for livestock, watering places, road accesses, timber for the winter, herbs and plants, plant medicine, and the harvesting of wildlife to sustain our lives. These are all traditional rights our ancestors experienced, and the ones that our community also longs to experience. For decades, we have had limited to no access to what was once our common lands. Today, those lands are managed and run by New Mexico Game and Fish. Those lands that I speak of are Ed Sargent Wildlife Management Area, Rio Chama Wildlife Management Area, and the Humphreys Wildlife Management Area. Next slide, please. This is only 44,398 acres of land. At one time, our common lands encompassed 594,515 acres, belonging to the land grant of Tierra Maria. This is roughly only 7% of the total common lands that has been lost, sold, or stolen, and much of that land will never be returned to the land grant. Next slide, please. The land has all too quickly been privatized and turned into top dollar real estate, promising those who purchase it views for days, peaceful sunsets, and the thrill of adventure for all seasons. Not only driving the market value of housing up, but putting those who were born and raised in the area in a position seeking homes elsewhere, leading them to find jobs and create their lives in other places. In my experience, those of us who do stay, I imagine, stay because we believe we can bring about change. But to what end? Every day is a reminder of the impoverished community we live in. Don't get me wrong, it's beautiful, but beauty only runs skin deep. It's superficial. If you look beyond the beauty of the mountains, rivers, and wildlife, we are struggling. Drugs are everywhere and available to those who just ask. And the jobs, we can't really talk about job creation. You either work for the county or for the schools, or you run your own business. And the education that we are giving our youth is watered down and more of disservice than anything else. We elected officials, when elected officials visit our area during election season, I imagine change is on the horizon. I think this is the year things will change. And in my experience, oftentimes the promise of my vote is enough, and all too often, some things remain the same. So today we are here to propose change we need in our community. We are all coming together, and we are asking your support to create this change. I imagine that when you got into politics, you were so excited, kind of like me, sitting here today, thinking you're going to change the world. And then after a while, the spark fades a little bit because you hear no, or there's so many barriers. And this is an opportunity, though. This is an opportunity that is knocking at our doors. And I hope it's one that you all can invite into your hearts. So I ask you to check in with yourselves, and maybe it's something that we all feel moved to act on and accomplish together. So our proposal, the slide in front of you that you're viewing says the Merced de los Pueblos de Tierra Maria proposes that legislation be drafted and endorsed by the Land Grant Interim Committee to provide the reestablishment of traditional use on the stewardship of the Sargent, Rio Chama, and Humphreys Wildlife Management Areas by the Merced de los Pueblos de Tierra Maria and its community members, with the eventual return of those properties to the ownership, control, and management by the Land Grant Merced. Next slide, please. In this proposal, traditional rights would be defined as communal livestock grazing, use of water, fuel gathering, harvesting timber, and gathering of soils, rocks for products, including herbs, roots, nuts, berries, fungi, and sap. Any other traditional activity that has substantial beneficial community uses that support the long-term cultural and socio-economical integrity of the community, including the traditional use resource management plan. Next slide. In this proposal, meaningful access is defined as unabated ingress and egress through existing roads, trails and paths, or permanent and temporary roads. Trails and paths specifically established for the purpose of accessing traditional use resources on the properties, including stream access for fishing and livestock watering, and the reopening of former State Road 29 for use by Land Grant Merced community. Next slide. This proposal would also include traditional use resource management plan, which we have defined as a natural resource management plan developed jointly by the New Mexico Department of Game and Fish and Merced de los Pueblos de Tierra Maria. So I invite you to all to reference your packets for more in-depth details as I dive into what the proposal includes. So go ahead and go to the next slide. So we are proposing a 5-year window after the passage of the act for the implementation of legislation and final return of the land. The window includes, this 5-year window includes 3 different phases: planning, implementation, and return of land. Next slide. So the planning phase will include community input and discussion defining the following areas. So identifying all traditional use resources, all water resources, all existing roads, trails, and paths. It would also address ingress and egress access. We would develop a livestock grazing plan, also a process for distribution of hunting permits to the land grant. We would collaborate with New Mexico State Forestry to develop a fuel wood management plan and identify areas where soil and rocks may be harvested. Acceptable types of recreation can be enjoyed. Next slide. Implementation phase will include establishing a process with New Mexico Department of Game and Fish for identifying areas of the land grant that will be eligible for free use and access to the wildlife management areas. Appropriate times of year when wild crafting and collection of antler sheds can occur. Also, the gathering of herbs, fungi, and vegetation products for personal use, free of charge from within the wildlife management areas. Establish rules and regulations for the management and distribution of fuel wood collection, the distribution of hunting permits, communal grazing and livestock, issuing permits for the removal of soils, rocks for personal use. Next slide. During this period, where the wildlife management areas are under management and control of Game and Fish, we imagine that we would see the heirs of the land grant Merced shall be allowed free access to any streams or lakes with regard to limits set by the New Mexico Game and Fish. The department will ensure that any stewardship opportunities that may arise from any project-specific actions within the wildlife management areas will be vetted with the Land Grant Merced Board of Trustees to determine what role, if any, the Land Grant Merced can play implementation of given project. After the lands are transferred to the Land Grant Merced, the Land Grant Merced and the department may enter into an agreement to allow the department's enforcement officers to continue to patrol the area and issue citations for violation under the department's jurisdiction. Next slide. Transfer of property. Our hope is that within 1 year of the passage of the bill, the Game and Fish Commission through the Department of Game and Fish will submit a report to the legislature, including a presentation before the Land Grant Interim Committee. The report shall include copies of all property deeds, surveys, chains of title, surface and groundwater right permits, and mineral rights for all 3 of these properties should be aware and make us aware of concerning the property transfers identified by the department. This report will allow the legislator and Department and Land Grant Merced to properly plan and coordinate the property transfer process at the end of the 5-year period, including conducting any required assessments or surveys and drafting of deeds and transfer documents. The transfer of the properties shall include any and all water rights, surface and ground, and mineral rights, surface and subsurface. Finally, the Merced de los Pueblos de Tierra Maria would greatly appreciate if this bill include language that provides all legislative approval necessary for the transfer to take place without the need to come back to the legislator prior to final transfer in 5 years. We realize that within that time frame, many elements can change, including the people whom sit before us today. In conclusion, I never imagined that I would be a person advocating for the rights of the land that my great-great-grandfathers fought for, and that my family for generations has fought for. So many injustices have happened. Generations have been affected and will continue to be affected. As humanity, as we know it, continues to swing on the cusp of inhumanity, we have the opportunity to swing the pendulum in a direction of righting the wrongs of those who disregarded the rights of those who created their lives on the Tierra Maria land grant. We all have choices in life, and we can continue on the path that others choose for us, or we can create our own path. Quiero darles muchas gracias por escucharnos hoy, and I want to thank you for your time and diligence in this matter now and in the future. Y ahora podemos tomar preguntas. If you have questions at this time, we are free.
Okay, before we go to questions, is there anybody else on the panel that wants to make further comments? This was very comprehensive. It made it very clear, the history, what you're asking for. Arturo?
Yes, Madam Chair, members of the committee, just wanted to point you guys to the packet that Lisa referred to. It is actually quite large. It's about almost 50 pages, and it covers in more detail some of that history as well as the details of the proposal, and then some of the historical documents for those of you that may be interested in kind of looking at this more. We wanted to provide that opportunity to you guys to kind of delve into it further. So just I sent that forwarded to Mark. Hopefully you guys have received it, or if not, you guys will be receiving it shortly. And if you guys have any questions about any of the materials that are in there, you guys can always contact me or anyone from the grant.
Great. Thank you, Arturo. Okay, so I see Representative Miguel Garcia.
Thank you. Thank you, Madam Chair. And thank you, presenters. That was an excellent presentation, Lisa. And thank you for stepping up and being part of the Terra Maria Board of Trustees. You know, young blood is always kind of enlightening and takes us oldie but moldies to a higher level of understanding. So your leadership is really welcome and really needed at this juncture. And you know, and the presentation was really real conclusive. I have to give Steve and Arturo thanks for kind of the division of labor that you did on the presentation, and each presenter kind of giving real specific information on their portion, and not being repetitive or going into the other areas of the other presenters. So that was really inclusive and conclusive and comprehensive. You know, this is what it's all about, Madam Chair and panel, in terms of the role and purpose of this interim committee. And, you know, in our first year in 2003, bipartisan effort, even though we were still kind of growing and kind of emotional, once with the committee was understanding some of the atrocities that happened to some of the land grants and their common lands, their way of lives and their tradition, their customs, it was easy for the members of the committee to really take up the banner back then that any property that a state agency owns that at one time were common, that these properties be returned back to these land grants. That was kind of the beacon call in 2003, you know, and some of the more ardent members of the committee were some of our Republican colleagues like Joe Carrero, you know, who kind of on the floor of the Senate kind of made that statement on some legislation that was going through at the time in 2004, as 2004 was basically the first legislative year that the committee undertook to address some of the legislation that we drafted, created in our first interim committee in 2003. And, you know, this is a really good proposal. I instructed Mark to draft legislation to address exactly what the three panelists presented. You know, Madam Chair, last year we took a tour to the Sunlands Valley to look at their traditional use efforts on the Sangre de Cristo portion, on the Colorado portion of the Sangre de Cristo land grant, and the 80-some thousand acres that they were able to get traditional use rights to. And that really wasn't a sightseeing tour. I basically envisioned that tour as kind of a preliminary step in terms of what we're trying to accomplish today with the Terra Maria in terms of getting the committee, getting the staff, and getting the Terra Maria land grant all on the same page, on the same site, listening to our fellow heirs on the Sangre de Cristo, hearing their story as to how they were victorious in the 35-year battle in the courts. And we're going to do the same on the Terra Maria, but not wait 35 years. We're going to do it in a 5-year period that is addressed meticulously, step by step, in the legislation that Mark is presenting, thanks to the proposals that have been brought forward by the land grant and Arturo with the Land Grant Council. And you know, I think the conditions are right to move forward with this initiative. I think the Terra Maria is kind of the perfect, if not ideal, site in which to undertake this effort. Mainly because it was the Terra Maria where the first land loss occurred through Thomas Catron. It was here where he put into effect his blueprint of acquiring close to 5 million acres of common lands of over 30 land grants in our state. And he was successful. And he did it in the most corrupt, the most corrosive, and the most devastating way, with the help of the government and government officials at his side every step of the way. And now we're going to undertake this endeavor with the Terra Maria, with government on the side of the heirs and of the Board of Trustees, the Terra Maria land grant. And we're going to make it right. Of all the wrongs that have existed historically, and the Terra Maria is such a valiant land grant. They took the advice of the Constitution, of state law, in seeking redress and seeking justice through the courts. And every court that they went to shut them down, spit in their face, and kicked them in the chins. You know, and they're still standing up, and they're still wanting to do this, the right thing for the right reasons through the right process. And I think this is a show of appreciation of the long fought battles of the Terra Marias and the positive outcome that can come from this. And yeah, we expect some resistance, if that's the proper word to use, Madam Chair. But the time and place, I think, and the historical point in time is strategic, that we move forward and give it our best shot. And so again, I want to thank the panel, and I want to thank the committee for really kind of standing at the side of the Terra Marias through thick and thin, you know, and through setback after setback. But we know, we have a saying in Spanish, you know, que la mentira dura hasta que no llega la verdad. And that's so true, that a lie will prevail until the truth comes to replace it. You know, and that's what we have at our side in this endeavor, you know, is that the truth matters, and that justice matters, and that the people, the native people in New Mexico, matter more than the special interests that are trying to further undermine our customs, our traditions, and our rightful place in history. So thanks again, panel, Lisa, You were great. Steve, like always, Arturo, thank you for being so consistent, persistent, really putting together a good proposal for the committee to address in the 2021 session. Gracias. Thank you, Madam Chair.
Thank you, Vice Chair Miguel Garcia.
No.
As the representative said, the presentation was very complete, very clear about what you're asking for. He's asked Mark to prepare it for our consideration in November. On November, I think it is, when we're meeting, that we were considering endorsement of legislation at that time. Steve, Lisa, Arturo, thank you very much for that presentation on TA. It was very important for everybody to hear the beginnings and the history and what it is that would right the wrongs. So we are now at that point in the agenda, everyone, for public comment.
Madam Chair, there's two legislators that have their hand up to speak.
Yeah, I just wanted to remind Madam
I'm sorry,
Chair.
Yes, Senator Martinez.
Thank you, Madam Chairman, Madam Chairwoman. It's kind of hard to follow Representative Garcia. He knows so much of the history of the land grants, and I really appreciate the leadership that he has had for the last 17 years. I've been in this committee for 16, 17 years, and in the last 16 years, I've witnessed so much that we've done for the land grants, in particular for the northern land grants, and everyone has stepped up to the plate to assist us and help us. And I think the presentation that Steve and Lisa and Arturo did was just wonderful. I really appreciate it. Unfortunately, we're going to have this piece of legislation drafted, and I won't be here next year, but I'll still support it, and I still can. And I really appreciate the fact, and I hope that I have seen so much legislation, and I've been a big part of a lot of that legislation that has passed, that has move the land grants forward, and I want to commend everybody in the committee. Like Representative Garcia said, there's been so much partisan unity through our members in this committee, and we have accomplished so much. And I'm really proud of everything that we've done to make life easier for the members of the land grants. And I'll always be there for you guys. And thank you again for the presentation. Thank you for staying strong and for believing in yourselves, and also for believing in me during the time that I was a member of this committee. I also had the opportunity to chair it for a couple of years, and I love this committee. I've learned so much. It took me, sometimes it took me 2-3 times to listen to a presentation or to different presentations to actually grasp it, but it's taken a long time. But I really appreciate your plight in all of this. So thank you, Madam Chair, members of the committee.
Thank you, Senator Richard Martinez, for all your support. We'll be missing you, but I know you'll be there with us in heart. Thank you.
Thank you, Steve. Thank you, Senator Martinez. We have Senator Linda Lopez.
Thank you, Madam Chair. And I just want to kind of echo what Martinez just said, and thank it. This is information and part of our history that needs to be shared with the communities, and not just northern New Mexico, but across the state, so that our young people understand and learn. about where we have been and where we have come from. It helps to tell that story. And stories are so important because they do tell the truth, as has been mentioned. And, of course, Representative Garcia, her leadership on this committee, and when it was founded, I still remember learning about it, and it took me a while to get on this committee because those who were on it was, you like the committee, you love this committee when you're on it. So I've been grateful to be on this committee over the years since, and I'd like to see this bill and see what else are the components as it comes forward, as the chairwoman just mentioned. But this is just thank you for your presentation, and thanks to each of you, Lisa, Stephen, when we come from the community and we come with our heart, that's what makes the difference, and that is what creates the change. So I just want to say some comments, Madam Chair. Thank you.
Thank you very much, Senator Lopez. Representative Susan Herrera.
Thank you, Madam Chair, and I'd like to thank all the panelists. This was a wonderful presentation. I just have some questions. The 40,000 acres that we're talking about, are there any private properties currently on those lands? Are they all owned by the state, and are those lands all cleared? That's what I want to know.
Madam Chair, this is Steve. No, there are no private properties on those properties. There are 3 separate properties that are in their entirety. So they're all belong to the Game and Fish.
Okay, so all the lands that you're talking about belong to the Game and Fish. Okay.
Yes, ma'am.
All right. Because I'm thinking about the Rio Chama Wildlife Management Area, and I know there's a little cluster, along the end of that road there. There's some clusters of properties and properties along the side, but it must be from the river to the other side that it's pretty much clear, and no private properties are there. Is that true?
That's true, and the private properties are on the east side of the highway. The west side is bounded by the reservation, by the Jicarilla Reservation, the Laguna de los Caballos.
Okay. All right. That was my main question. Thank you. That's all I had. Thanks. I'll study this further and get back to you. I'll study it further and get back to you on some questions that I have. Okay. Thanks.
Thank you.
Thank you very much. Mark, my screen is frozen. Are there any other hands up?
Madam Chair, those are the only hands I'm seeing up right now.
Okay, I want to thank thank you. I want to thank the panelists, and it's 3:00, but I want to go on to public comment because there are some people waiting to say a few things. So we are now at that point on the agenda for public comment. And Arturo, I know that you wanted to comment earlier about the wildfire, some component, and I didn't let you in. So is there something you want to talk about?
Madam Chair, can you hear me?
Yes.
Okay, sorry, my screen is also frozen and it's giving me the little spinning wheel of death, so I wasn't sure. So I'm glad you can still hear me. I'm sorry my video is not working. Yeah, actually, I think just a couple of quick comments. One, in terms of the wildfire, we did have the land grants that did participate. As Vanessa mentioned, the Tehuque land grant and the Chirili and those most recent fires. And there was some really good coordination that went on between those the coordinating agencies and making sure that they kept the land grant president in the loop. Now, anytime there's a fire on the Forest Service, they'll notify us if it's near the land grant community, and we'll provide them with the contact information, and they do their best to try to get that out to them. And then in the case with Tehuque, they actually utilized their community center as the command center for that last fire, the Ojo de los Cactos fire. So those relationships are getting better in terms of working with the land grant communities, and the more work that this committee does and the more recognition that we've gotten over the years has definitely helped that. The other comment, Madam Chair, that I wanted to bring before the committee was something that we've been running into recently. And since this is kind of a strange interim season, I wanted to propose something that I need to get on because the last meeting is going to be the final meeting where you endorse legislation. And one of the things we've come across as an issue now in two separate instances and two separate land grants is the ability or authority for land grant boards of trustees to purchase property. It's not complete, it's not inherently clear in the statute that that's allowed. And I imagine that the reason it's not inherently clear is because the statutes are so old. They start during the territorial period when land grants had land to manage, and they weren't necessarily trying to reacquire common lands. And so we've come across it with a couple of title companies as well as with the U.S. Forest Service in this transfer of the Queda Lumber Visitor Center, where they wanted to ensure that the land grants actually have the authority to purchase and acquire land. We were able to solve it in the case of the PLVC because the federal government in their disposal is a entity that it's another government entity, and because the land grants are political subdivisions, they can procure from a third source procurement, and the federal government is defined as one of those. So that's not a problem. But when it comes to private acquisitions, that's where it becomes an issue. Can you guys still hear me?
Yes.
Okay. So, Madam
Yes.
Chair, the request or the specific ask is that you guys would consider amending the general provisions under I think it's 49.3 that enumerates the powers, or 49.1.3 I should say, that enumerates the powers of the Board of Trustees and make it clear and specific that the land grant board has the authority to acquire property, and that would solve some of the issues we're running into with title companies, for example. Don't see that land grants have that specific authority, and so it's running into issues with them being able to do those business. And rather than us have to search all the rest of the statutes to find where something fits, actually just make it clear that they have that authority and ability.
Okay, so Arturo, would you please send a draft of some of that language to Mark?
Yes, I will, Madam Chair.
Okay, thank you. The next person I have on the list is Vanessa Chavez.
Madam
Thank
Chair,
you, Madam
she took her
Chair.
hand down.
Vanessa, did you still want to make a comment?
No, ma'am, I didn't. Thank you so much for the opportunity.
Okay, thank you. Anyone else, Mark?
Sarah, is there anybody on the phone?
Not that I see, no.
Okay, so committee members, if you have something specific from these meetings that you would like Mark to draft legislation about for our consideration, would you please get it to him as quickly as possible so that at our next and final meeting, which I believe is November 20th, that it would be considered for endorsement. But if you don't provide him the information, there's no way he would know. So are there any questions or comments from the committee members?
Madam Chair, this is Miguel. I have a question.
Yes,
for
Mr.
Mark.
Chair.
I have a question for Mark.
Yes.
Mark, is the AG still requiring, is the AG still pursuing doing their legislation that they've done last couple of years regarding that language that allows them to assist, quote unquote, land grants? Are they still wanting that this next session?
Madam Chair, Representative Garcia, I have not done, I don't have a request from them on anything.
Madam Chair.
For drafting purposes.
Madam Chair, this is Arturo with the council. I do know that they are interested in pursuing that to sort of strengthen the language of the treaty division. Is that what you're referring to, Madam Chair, Representative Garcia?
Yes, that's the language that I'm.
Yeah, Madam Chair, I know that they're interested, and I can reach out with them and talk with Novella. She had actually reached out before the interim session started to see if there was any legislation, including theirs, that was going to kind of be worked on that they needed to comment on. So I can definitely get with their office and make sure that they have provided some draft language to Mark to work with.
And also, Madam Chair and Mark, what are you proposing, Mark, in terms of the Anton Chico issue? Is the Board of Trustees still wanting to pursue that natural resource officer like legislation, or are they kind of modifying that for something else? What can we expect on the November 20th meeting regarding that?
Madam Chair, members of the committee, I need someone to open up a file with regard to drafting a bill. I don't have any direction right now from anyone. Did that come through clearly?
Yes, it did.
Well, since Representative Salazar is retiring, I might be the closest body to Anton Chico, so I'm asking you to open the file.
Okay, I will open a file and we can discuss how the specifics of that draft offline.
Okay, thank you. Are there any other questions or comments from committee members? Okay, committee, I thank you very, very much for being with us today. I thank all the presenters. I thought everybody was very well prepared. Committee members, you have a handout for almost every presentation today. Thank you. Be safe, be healthy, and watch out. If you're interested, I think tomorrow, Thursday, the governor will be doing her update. Okay, thank you very much. See you. Bye.
Thank you. Be safe, everyone. Cuídense.
No se vayan, quedando.
Gracias a todos. Thank you so much for everything on behalf of the Maria Land Grant. Thank you for your support. God bless you.